Good evening, Bryce. Thank you so much for joining us this evening. I'm sure we're going to have a remarkable time. So many of our colleagues are still logging on. We're at about 192 attendees so far and fast increasing. Now we're already at 204. And so as they log on, I'm going to just give you an overview of basically what takes place here this evening, which we've talked about. And I'm sure everybody's going to be really excited to hear what you have to say this evening. And then we will be able to take it forward from there. So, as everybody's logging on, I know Dr. Kinoshi has been away for quite some time. Dr. Kinoshi was in Morocco and he left us all here in South Africa. And he should be back right now, but I'll be running with the presentations and the facilitation this evening. For those of you that don't know me, I am Dr. Burton Shinners, and I'm the Chief Medical Officer for the Clinix Health Group. And as you know, for quite some time now, the Clinix Health Group has been running and sponsoring these events where every Thursday at 6 o'clock, as colleagues, we're able to come together and discuss various topics that are beneficial for our individual practices, but also on a group level, how to help us navigate these trying and difficult times that we are going through. One, in providing better healthcare for our patients, but also how to navigate now more and more as the practice that we are rendering is being scrutinized all the more. And hence we have a speaker here, Mr. Perrett, Bryce Perrett, who's here tonight. And he's going to be one of several speakers, as you've seen quite a shift in our presentations to help us navigate, especially as people become increasingly litigious in their conduct and looking to sue doctors or find fault or submit summons or have some form of demand letters that arrive at our desks, and they want certain compensation for what they feel we've done wrong in terms of their healthcare management. So tonight we have Bryce here from Norton Rose Fulbright. I'll give further information and a better introduction for him shortly. In the background, we have the Clinix Health Group support team, Tolakele and Sam as always. And you know that they will be muting everyone's mics while Bryce is presenting, but please feel free to keep submitting your questions. And for those of you that would like to ask the questions directly, we'll unmute your microphones towards the end of the presentation, and please feel free to direct those directly towards us or Bryce himself following the presentation that he puts forward. Just a number of protocol elements. As you all know, all your microphones will be muted. And Bryce didn't want to be interrupted during the presentation. He says he interrupts himself all too often anyways, so we will not allow for that to happen. And then for those of you that would like your CPD points, it's important that once you receive the link to click on the link yourself. And then once you go there and you register, you put in your name, surname, your address, your discipline, and that goes through to us, to the HPCSA, so that you are going to be automatically awarded with your CPD points. But if a colleague or somebody else has registered on your behalf and sent you just the link to arrive here at this presentation, you may not receive those CPD points. So please make sure that you yourself register for tonight's session and all the subsequent sessions so that you do not forfeit those CPD points. And because of the backlog, it's taking anything between, immediate and 2 weeks to receive those points. And if you don't, please direct it directly to Tolakele and Sam, who are presenting here tonight. We will assist you in getting those points to you. And then, as I mentioned earlier on, we're seeing that there are a number of trends that are happening. So during the ombudsman had a session and a seminar about 2 weeks ago, and there seems to be a trend where cases that are submitted to the ombudsman for investigations, where they felt doctors or hospitals who were negligent in practices, and patients felt that they were not appropriately treated. Normally, they would submit these cases to the ombudsman. The ombudsman would do an investigation and then write a report to the facility or the doctor, and then they would provide the report to the patient as well. And so in the past, the ombudsman would make recommendations on what could have been done better and what needs to change, and they would like evidence for what it is that we did correctly once those reports were received. What did we do to mitigate the risks or address the complaints on behalf of the patient? But what the ombudsman is seeing is that more and more of these complaints that are coming forward from these patients, once the report is received, they're basically looking for some form of validation that they may continue and pursue the doctor or the health facility if the report makes any form of suggestion that there was negligence or there was any form of harm that was brought to the patient or some form of a sentinel event or anything to that matter. So going forward, to protect the doctors and to protect our practice and protect our patients, basically, it's going to be important for us to more and more focus on what is happening and the trend of where the health practice is going, so that you are not unaware of what's going on. In the future, perhaps once a quarter, you will be presented with a number of judgments that have come through the court system. Sometimes it looks quite direct and straightforward, but it doesn't always end up that way. And Bryce will most certainly give you an idea of what it is that I'm talking about. So Bryce, I'm going to say welcome once more. And just as an introduction to everybody, I know the Norton Rose Fulbright team for quite some years now. And so Bryce is actually he's based out in Umhlanga. He's working with his colleague, De Niro Play, and he himself, Bryce, is a director in the insurance litigation team, which is based in Durban. So he joined the practice around 2020, in 2014, Bryce, in January, that was. Yeah, and so his focus is predominantly on the insurance litigation, including the professional indemnity, public liability, personal injury claims. And so from Norton Rose point of view, they specialize in assisting hospital groups and doctors in defense, and try to keep those cases out of court and settle them if necessary, or to help approach it properly. So Bryce is also quite experienced in commercial and administrative law related to litigation. And so he will assist with things like tender reviews, calling up security on debts and foreclosure related disputes. I know he has an LLB, and Bryce and the Norton Rose team, they basically also assist the Department of Health with all of their cases, which generally ends up in court. And so Bryce, I'm going to hand over to you. I know you said I shouldn't say anything about you. I should just tell everybody this is Bryce. Go ahead, Bryce, and speak. So this is your moment. Thank you so much, Bryce, and we'll catch up at the end.
Thank you, Burton, for the introduction. Before I start interrupting myself, I hope you can all hear me clearly.
Yes, thank you,
Super.
Bryce.
All right. I must say I'm very impressed that we've got 300 odd doctors on the call. I think in terms of diligence, you are outshining what I would suspect the legal profession would be doing on a Thursday night. So it's great to be with you. And from my side, thanks very much to Clinix for the opportunity to chat to you this evening. Thank you, Burton, for the introduction. So I'm not going to say more about myself. What I'm here to chat to you all about this evening is the right to emergency medical treatment on the part of patients or members of the public, and then the converse obligation on the part of medical practitioners not to refuse emergency medical treatment to patients in the circumstances where that arises. I'm sure all of you would be aware of that duty or that obligation on the part of practitioners, and perhaps most of you may also be aware of the source of it, but the source primarily sits in Section 27(3) of the Constitution, which says no one may be refused emergency medical treatment. And some of you who know the section 27 well, there is a right before that, the right to healthcare, section 27(2). And one needs to draw the distinction between the vertical application of that right, so being the application or the obligation sitting on the state to give effect to that right and provide for the delivery of those rights within means to the public, and this right, which is both of vertical and horizontal application. So not only is it an obligation or a right that has an impact in terms of what's required of the state, it also has an impact in terms of obligations on the part of the private sector role players to comply with that obligation. So it's not like the right to healthcare itself in section 27(2). It also has implications for practitioners, healthcare facilities within the private healthcare space, in addition to the public healthcare area. And to give effect to that right, the government or the state enacted the National Health Act, and within Section 5, or within the National Health Act, Section 5, there's a provision that a health provider, health worker, or health establishment may not refuse a person emergency medical treatment. So that is the statutory provision that gives effect or carries out the right in section 27(3). Unfortunately, moving on from that, the question then becomes, well, what exactly is a medical emergency? And the National Health Act is silent on that, but we can look at other sources in terms of legislation and the case law to get some sense of what the requirement is there in terms of what constitutes a medical emergency. And one good example, although it is talking about prescribed minimum benefits, is Regulation 7 to the Medical Schemes Act. And what that says, as you can see on screen, is that an emergency medical condition means a sudden and at the time unexpected onset of a health condition that requires immediate medical or surgical treatment, where a failure to provide medical or surgical treatment would result in serious impairment to bodily functions or serious dysfunction of a body organ or part, or would place the person's life in serious jeopardy. And that isn't binding, or wouldn't be binding on you as practitioners or on private sector health facilities. Because, as I say, the context of that is it's dealing with prescribed minimum benefits. So it isn't directly tied to the right in terms of section 27(3) and the provision, therefore, in section 5 of the National Health Act. But it is a useful definition, and you'll see from the comments in terms of what the courts have said about it, that there's some alignment there with what's dealt with in that regulation. There was a significant case around the time of the enactment of the Constitution, which dealt with the question of what is required and what is expected of parties in terms of giving effect to section 27(3). And that was the case of Subramani, and it happened or played out to a large extent in my part of the world, down in Durban and KwaZulu-Natal. And the factual background to it was that Mr. Subramani was very unwell. He was in chronic renal failure, and he was accessing dialysis through the private sector for a period of time, but got to the point where it was too expensive for him to afford to continue to access it. And he required that dialysis in order to continue living, to avoid passing on or dying. And he approached Addington, which is a state hospital, some of you or many of you may be aware of, on the beachfront here in Durban. And Addington at the time had a number of dialysis machines. A number of them weren't working, but they had some that were operational and could provide dialysis. But they turned him away, turned Mr. Subramani away, and said, because of the constraints, the resource constraints that they were under, they were only able to provide and could only accommodate acute cases. So those are cases where, by receiving dialysis, patients would be treated effectively and the health condition that they were suffering with would be resolved. Whereas what he required was ongoing chronic care in the form of dialysis. And in short, the Department of Health said that because of the availability or limited availability of resources, they weren't in a position to meet his need there, even though it was clear or common cause that without dialysis, he would eventually would die. He then brought an urgent application in the High Court in Durban, and part of the relief that he sought was an order compelling the Department of Health to provide him with dialysis at Addington. And the litigation went all the way through to the Constitutional Court to ultimately decide whether what he was talking about in that context what amounted to a refusal to provide emergency medical treatment to a patient by the Department of Health in KwaZulu-Natal. And ultimately, the court there defined a medical emergency as a dramatic, sudden situation or event, which is of passing nature in terms of time that can be cured through medical treatment. And in Mr. Subramani's instance, he had a chronic condition that wasn't going to be cured, that he would require ongoing treatment for. So it wasn't a dramatic, sudden situation or event, that it wasn't passing in nature, it was ongoing in nature, and it wasn't going to be cured by the treatment that he was seeking. So in that context, ultimately, the Constitutional Court held that what he was talking about didn't constitute emergency medical treatment, and there was no breach of that right on the part of the Department of Health to refuse to provide him the dialysis in that context. And it's quite harsh, but one of the judges, or there was a minority and a majority judgment, but the majority dealt with the fact that part of the question in terms of the right not to be refused, or the issue around the right not to be refused emergency medical treatment, is linked to the right to life. And quite interestingly, the court commented and said, yes, there's a right to life, but there's also not a right to have one's life prolonged indefinitely, or to prevent someone from dying indefinitely. And so in that context, as harsh as it sounds, if you're looking at Section 27.3 only, the duty is not to prevent someone from dying indefinitely. The duty is to address and provide treatment in an emergency medical situation. And that's what the court dealt with in Subramani quite nicely. The HPCSA has provided some guidance, and their commentary on it suggests that it's a threat to life or limb, including a perceived threat, so where there's a perceived possibility of a threat. And that final point at the bottom of the page is perhaps a synopsis of the case law and the relevant legislation. And to summarize it, what a medical emergency is likely to constitute is a situation that arises where a person's faced with the real possibility of death, serious bodily injury, or deterioration in health resulting from a sudden situation or event. So practically, what does that mean on the ground? And lawyers love saying it depends, but in this case, to a large extent, it's fair to say that you know it when you see it. And to a significant degree, it really depends on the individual nurses or doctor's reasonable assessment in the circumstances. In an emergency unit setting, you're probably going to be saying that anyone that's triaged as a red or an orange, certainly a red and an orange, is going to be suffering or experiencing a medical emergency and would be entitled to emergency medical treatment. There are practical considerations too about time to transfer. So if you look at that, choose the table on the right-hand side of the screen. If you're talking about 10 minutes, if you're transferring to a hospital just across the road, a state facility where you've got a private patient who's unable to pay or unwilling to pay for private healthcare, then if you can transfer within 10 minutes in the context of an orange, maybe you'll be all right. But in most instances, you're probably going to need to treat or deal with the patient in the emergency unit and possibly admit to the hospital until they're stable enough for them then to be transferred, as the case may be. So practically, just to summarize, I don't think you can define it strongly, or the courts have certainly steered away from giving a limited definition of what constitutes a medical emergency, because there's a wide range of conditions or circumstances that may well fall into that category and then require the provision of emergency medical treatment. So then the question is, what is emergency medical treatment? And once again, the Constitution, the National Health Act, the Health Professions Act, Health Professions Amendment Act, and the rest of them don't define it. The courts also don't define it. And perhaps again, it's because there's a wide range of circumstance or a wide range of treatment that may well be required or be considered appropriate to address an emergency situation. So defining it doesn't necessarily take things any further. In a private setting, so either in a private practice, doctor's practice, or private hospital setting, what's probably required is what's immediately reasonably necessary to address the medical emergency, stabilizing the patient, and then referring or transferring appropriately. And that's quite important. And I'm going to touch on some case law or case examples to illustrate the point, and also illustrate what we're talking about in terms of the right more generally. But it doesn't help if you're transferring to a level of care that's inappropriate in the circumstances that could well result in a compromise to the patient, or an adverse outcome to that patient, where they've been sent somewhere that they shouldn't have been sent, or doesn't have the necessary capacity or capability to deal with them. And a really good example of this is a case involving a rugby injury down in the Western Cape. And it's pictures like that that make my wife say that my son can never play rugby. But this was one of those tragic rugby injuries that seem to happen from time to time, where a gentleman playing club rugby suffered a spinal injury, and it was in the outlying areas of Cape Town. And the closest hospital that he was taken to, rushed by ambulance to, was Westvleur. And Westvleur, if I understand it, is a district hospital. It didn't have a spinal or orthopedic unit, and the diagnosis was made fairly soon on after arriving at Westvleur that this gentleman had a spinal injury, and that what he required was a spinal decompression surgery urgently, to avoid him suffering from a permanent paralysis. And this was on the evidence known by the doctors at Westvleur. What ultimately happened, though, was there was a delay in transfer. There was a hospital available, a helicopter available around the time that the diagnosis of a spinal injury was made. But for whatever reason, that wasn't utilized, and the gentleman was transferred by ambulance from Westvleur to Groote Schuur, which was the next level up in terms of the referral pathways applicable at the time. That's where patients were supposed to, in terms of policy and procedure, to be sent. And there was a delay there, and ultimately what was required was a surgery at Conradie Hospital, which was a third hospital with a specialist spinal unit, also within the Cape Town area. And there was a delay of almost 12 hours. I think it was just over 12 hours, in fact, from the time that the gentleman arrived at Westvleur until he eventually arrived at Conradie and received the spinal decompression surgery. And the time frames, if I remember correctly, was 4 to 6 hours at worst for that procedure to be done. If it wasn't done within that time period, you could expect permanent issues. And of course, 12 hours was too late, and that's what ended up happening with this particular patient. This matter went all the way up to the Constitutional Court, and ultimately what the court found was, despite the department saying, well, at no point did we refuse emergency medical treatment. Whenever this gentleman presented at a hospital, he presented at Westvleur, he was treated immediately or dealt with immediately. He was then referred, as was required, up to Groote Schuur, and then from Groote Schuur he went on to Conradie, where he ultimately had the procedure, unfortunately without effect. And what the court said, well, that's all well and good. Yes, there was no turning away of this gentleman at any point, but the failure to adhere or to proceed with the necessary urgency and to make use of the helicopter that was available to transfer, for example, and not to adhere slavishly to the referral pathways that were in place at the time, and to, rather than referring to Groote Schuur, to contact Conradie directly and refer there to circumvent or avoid the delay. That was negligent and a breach of the right not to be refused emergency medical treatment on the part of the Department of Health's employees in the Western Cape. Part of the problem there, just for interest, is, and when I've done this presentation previously to doctors, a lot of them, and quite understandably, say, well, you know, the referral pathways are a matter of policy that are put there by management, you know, by the department for a reason, to avoid flooding facilities and overwhelming them, and to manage the resources that are available. But the problem in this case was that that evidence wasn't led by the Department of Health. So no doctors came from Westphalia to testify about the fact that that was what was expected of them, to refer up to Groote Schuur, and then from there onward referral would happen. So that was part of the problem practically. But I do think that even if that evidence was led, it would have been a challenge. And the takeaway from a practitioner's perspective, and from a private healthcare provider's perspective, is that you can trip up if you adhere slavishly to protocol. So, for example, if you are referring into the state from a private hospital setting, one must be cautious to avoid just going with the closest, or just going with the norm in terms of, all right, this is who we always refer to, we'll just refer there. Some cognizance should be given to the fact that perhaps there's pockets of services in various hospitals that aren't available elsewhere, or where specialized services are required, particularly that you're not referring the patient somewhere where there isn't that service available, for example, from a private setting into the public setting. So it's a very interesting case. I think, unfortunately, the department was let down to some extent by the fact that evidence wasn't led of the doctors explaining the situation on the ground and why referral pathways, for example, are in place. But the takeaway, as I said, is don't adhere slavishly to policy in an emergency situation where you should or could know better in terms of dealing with the patient effectively and efficiently to ensure that they get the care that they require as timelessly as possible. The next case study is Valkovics versus the Health Professions Council of South Africa, which was a decision recently up in the Pretoria High Court. And here it originated as an HPCSA complaint where the doctor respondent, an intensivist, was found guilty of unprofessional conduct. And what happened factually in this case, this doctor was the intensivist on call at a private hospital, and a gentleman presented at the emergency unit, and the emergency unit doctor assessed him or diagnosed him as having kidney and heart failure, and that he required admission either to high care or ICU. So the emergency unit doctor phoned the intensivist and inquired whether he would be willing to take the patient on. The patient was a private patient, so not a medical aid patient, and the intensivist refused to accept him as a patient. And what was critical there in terms of the ultimate finding of the court was in that phone call between the intensivist and the emergency unit doctor, the intensivist asked, is it an emergency situation? And the response from the emergency unit doctor was, no, it's gotten progressively worse over a period of time, and that he had been stabilized as things stood at the hospital. So the doctor, the intensivist, elected not to come in and see the patient. He said, if it's not a medical emergency and it's not a medical aid patient, I'm not willing to take the patient on. What then happened was the emergency unit doctor phoned a number of other intensivists, and they all also refused to accept this gentleman as a patient. And he was transferred from the private hospital to a state hospital, where he passed away the next day. The family then made a complaint to the HPCSA, and it was made against the intensivist who initially had refused to accept the patient. And the finding by the HPCSA was that the intensivist conduct in refusing to accept this patient amounted to unprofessional conduct. The primary reason for it seemed to be that the suggestion by the HPCSA that this intensivist was more concerned about cash than treating or dealing with the patient. But when the matter was taken on repeal to the High Court said, well, the duty in terms of Section 27(3) is to provide emergency medical treatment. And in this specific case, the patient was stable. The practitioner had inquired whether or not it was a medical emergency and had been told no. And he was quite entitled to elect not to accept the plaintiff as the patient as a patient in those circumstances, and that the finding of unprofessional conduct was incorrect. I think in terms of comment, it was quite a risky call to make. I think a court approached with a similar set of facts may well decide that where you haven't gone and actually seen and assessed the patient, that perhaps that might constitute a failure. But having said that, in these specific facts where it was communicated to the intensivist that, listen, this gentleman's stable, it's been an ongoing issue and or a progressive issue, and in the emergency unit's doctor's view, it wasn't a medical emergency. He was entitled not to accept this gentleman, and that his conduct wasn't unprofessional. So that's just an example of criticism initially at HPCSA stage, ultimately being overturned at the High Court, where on a factual level, it was suggested that there wasn't a medical emergency requiring this intensivist to provide treatment to this patient particularly. A final one or case study that I thought might interest you as a grouping in terms of just how challenging dealing with this situation can be, both from a hospital and from a private hospital and a private doctor perspective, is I was involved with a matter a couple of years back for a private hospital group, where a lady arrived at a hospital, delivered in the emergency unit, a very prem baby, and the baby was required to be admitted into the NICU. The baby was being fed by a nasogastric tube and was ventilated, so not well and not stable. And the mother wasn't on medical aid, couldn't afford, advised the hospital she couldn't afford to pay for the treatment that the baby was receiving. And now you have a very prem infant in an NICU ward, obviously taking up a space and resulting in a cost being incurred by the hospital. The pediatrician who accepted the patient, or the child as a patient, was involved, of course, and made inquiries with a state hospital nearby about accepting the baby as a patient. And the state hospital had NICU facilities, was able to accept, had availability in terms of a bed, and was willing to take on the baby. When the pediatrician approached the mother about transferring, the mother refused. And that left the hospital in a very difficult situation, because if the mother refuses, where does that leave one? And when we were brought in, the intention was to bring an application to the High Court as the upper guardian of all minors to rubber stamp and approve that transfer. Now, the problem practically with that is motion courts around the country are notoriously slow, and you'd bring it by way of an application. So that's in motion court. And the earliest that we were likely to be heard, we could be heard urgently within a day or two, but the courts generally aren't interested in commercial urgency. So they're going to have very little sympathy with the private hospital group who's saying, look, we're losing thousands and thousands in terms of having this baby in our ICU. Please, can you allow us to transfer it to the state? And you must hear this on an urgent basis before all of the other very important cases on your court roll. So there was a concern about whether we would succeed on urgency, which means then you are in court in most of the jurisdictions in South Africa. You're probably only going to get to court at the earliest in a month or two, probably 6 months down the line, or even worse. So practically speaking, you caught between a rock and a hard place. Thank goodness, with a bit of strong arming, we were eventually, after a weekend of letters back and forth and meetings with the patients, the baby's mom, we eventually managed to persuade her to agree to the transfer. She signed a document, signed consent, and then we arranged for transfer with emergency medical services. And the baby was stable enough to transfer at that stage, so it was to go ahead. There was a slight aside there in that what then happened was the mother arrived at the hospital with a gun when the transfer was supposed to happen and tried to prevent it from happening, which set off another chain of events. But ultimately, when those were dealt with, we were able to have the baby transferred to the state hospital, and the situation was resolved. But that's just an example of how challenging things can be. Obviously, there's a pediatrician treating this baby in the NICU, taking appropriate care of the baby. You've got a hospital who's got an NICU bed that's been taken up in providing that care, which is, I suppose, as it should be. But it is challenging for commercial reasons for both parties to be put in that situation. So having dealt with those case studies, I'll close just with some practical thoughts, or closing thoughts in terms of the implications of the right and what that might mean for you as private doctors and as persons involved in private practice generally. And practically, especially in the emergency unit context, how does one decide whether or not a patient is experiencing a medical emergency other than assessing them? So I don't think you can ever get away where someone presents at an emergency unit, with a complaint. I don't think that you can, in the majority of instances, get away with not at least assessing, because without assessing and triaging and coming to a conclusion about what the health condition of the patient is, how do you know whether it's an emergency or not? There might be some obvious things where you would immediately be able to say, listen, this patient would be categorized green, and then you might be able to say, listen, if you're unable to cover the costs, you would need to go elsewhere. But certainly, where there's a suspicion of something that serious in an orange or a red categorization, then you might well need to deal with what's required in the hospital, possibly admit, and as I said, stabilize and then transfer appropriately where possible. An important thing to remember is that the requirement or the obligation on a private healthcare facility and on private doctors is that you may not refuse emergency medical treatment. So that firstly means that you have to be in a position to provide that medical treatment, and there has to be an element of that treatment being effective or being of assistance to the patient. So from a resource perspective, you can't be expected to provide outside of the resources available to you in terms of the medical emergency requirements of a particular patient. And a prognosis, whilst this is perhaps extreme, if intervention is not going to assist or change the situation, then the requirement of a situation or a condition that can be cured with medical treatment is not met. And so the right and the obligation in terms of Section 27.3 isn't met. Practically, the situations where that might arise are perhaps quite slim, but a silly example is, continuing with resuscitation indefinitely, where it's clear that the patient isn't going to recover in a particular circumstance. Then just some comments, and this is directed primarily towards the doctors on the call, or the practitioners on the call, is we don't have in South Africa Good Samaritan legislation, like, for example, in the States, where there's a clearly legislated requirement that in an emergency situation as a doctor, you are required to intervene. But if one looks at the HPCSA's ethical rules as well as decisions previously on inquiries, the position is that you are required as a healthcare practitioner to intervene or to provide emergency medical treatment should you come across, for example, a motor vehicle accident. There are requirements in terms of you being in a position to provide that care or having capacity to provide it. So, for example, if you're a passenger in a car and you've perhaps had one too many to drink and you aren't in a state of mind to be able to address an emergency, then that would constitute an excuse. Another example is, for example, where your health or your security is at risk. So that would be where you come across an accident scene in a dangerous area, or where the traffic situation is such that you would be at risk getting out of your vehicle to go and assist. That might be an excuse. But then in those circumstances, the suggestion is that you would have an obligation to report the accident, call an ambulance or the police and so on, and in that way provide assistance, and also to remain on site if you aren't at risk until such time as they arrive. An interesting decision in Australia was where a lady doctor came across an accident, didn't stop, but did drive to the police station to report it. And she was found to have acted unprofessionally by the regulator that side for failing to stop and provide assistance, because she had the necessary expertise and capability of doing that. Besides from those Good Samaritan type cases, a final comment, and this is what the cartoon is getting at, is if you are required in a hospital or in your practice setting to provide emergency medical treatment, you are entitled to charge for that. So whether you decide to or not is on you, but just because there was an emergency situation and you had to deal with what's required post haste and weren't concerned about medical aid approvals and so on beforehand, doesn't mean that you aren't entitled to charge. So if, for example, this NICU baby case that I spoke about, the hospital in that situation is perfectly entitled to charge the mother for whatever happened or that was dealt with in the emergency unit in terms of the delivery, and they're also perfectly entitled to charge or raise a charge for the NICU admission. Whether or not practically, where you're dealing with an indigent patient, whether practically that makes any difference, raising an invoice or not raising an invoice to getting paid, is a different question. But just for your information, it's not the position that you have to waive your fee in that type of a situation. And that, from my side, is it. I think we have a fair bit of time in terms of questions, so I'm very happy to take them.
Bryce, thank you so very much. You are far from being done. I'm going to ask you to please move to, there's two things here. The one is the last slide about the African Health
Let me
Awards.
share again.
So that
Sorry, I
while our
jumped out of
colleagues
there
are on
too
the
quickly.
line, and then there's a request here about the Subramani case as you were speaking. People were coming in on that and were quite curious to find out what that was about. And then we'll go directly to the questions. So as you can see, thank you so much, Bryce. As you can see, there are about 468 attendees, another three in the waiting room. We told you that it will be well attended. So everybody that's on the call, you are probably all well aware of the South African Health Excellence Awards. And so for this year of 2025, the Health Excellence Awards will be taking place again. And for all of you that would like to nominate any of your colleagues in any of the disciplines and the various components of our trade, if you could please bring forward any form of nominations. We do have a link or a website where you're able to go on there. We can post it in the message board for you to go there. There will be also uh, what do you call a QR scanner thing so that you can scan it and you'll be able to get more information on that. So the entries are going to be closing on the 6th of October. So for those of you who do have colleagues that you would like to nominate for being excellent in any specific area of our industry, would you please kindly nominate them and put their names forward so that they can be recognized on the day that we celebrate our colleagues for excellence in the healthcare industry. So please feel free to go ahead and nominate your colleagues. Bryce, as I mentioned, would be too much to ask about the Subramani case. As I said, you were just, as you came on, some were joining on that, yeah.
Can I stop sharing just so that I can
Yes,
see people when they and try and see some of the questions? That's
of
fine.
course, of course.
Okay, great. If there was a particular question on the Subramani case, but I'm happy to just recap it very
Yes,
briefly, the kind of the major points. And I think the major point there is if you're talking about an acute condition, that is the trigger for the right to an emergency medical treatment. Whereas if it's chronic, so chronic renal failure, for example, in Subramani's case, and you are requiring ongoing treatment, then it wouldn't fall within the Section 27(3) right to emergency medical treatment. It might well, and some of you might be aware of I think it was in the beginning of this year, there was the Cancer Alliance judgment up in Gauteng around the provision. I think it was also of dialysis, sorry, not dialysis, chemotherapy up in Gauteng by the Gauteng Department of Health. And there, the court said it didn't say that, didn't compel them to provide it at present, but it said you are required in terms of your responsibilities as an organ of state, as the department up in Gauteng, you need to roll out chemotherapy or take steps towards rolling out chemotherapy for the population to a larger extent. So that is slightly different in that you're not dealing with you're dealing with the provision of a chronic type of treatment or something that might be required over an extended period rather than an immediate emergency type situation as you'd traditionally imagine it. But that's an interesting development. But that Subramani case makes it clear that in the resource constrained setting within many of the departments of health, you can't say that you've got to turf it out and have to provide this chronic care in an emergency situation like Mr. Subramani, where he needed dialysis and the resources only allowed for acute management. So that was the decision of the court there. And the comments, if any of you want to get a real sense of, a full sense of the scope of the right, that's the case to read. The Oppalt one is interesting in terms of the process and the fact that even though you admit someone, deal with them, don't turn them away, you can still fall foul of the duty to provide emergency medical treatment if you are constructively considered to have refused it by failing to take appropriate steps to direct that patient to the appropriate care and to manage them appropriately. Yeah, so the Subramani case is really excellent from that perspective, and is the classical case that sets out the law in our country in terms of what the scope of Section 27(3) is.
Yeah, Bryce, yeah, and we're going to go into the question shortly. We had as part of a clinical risk committee meeting early on with a number of our professors and the Clinix clinical risk committee, and they were trying to understand what the difference is when you are assessing a case between the medical impact on the patient versus the legal. So does it necessarily mean if you fall foul from a medical point of view, for instance, you don't give a patient enough information for them to have give informed consent, does it legally necessarily mean that you fall foul of the law?
Yeah, that's an excellent question, and we wrestle with that sort of thing frequently in what we do. And maybe I can give another real life example of this. But it involved a child born prem and needed to be fed, and the doctor prescribed certain feeds and volumes of feeds, and the nurses just simply failed over an extended period to carry that order out in accordance with the doctor's instructions. And there was a period of hypoglycemia, and there was suspicion that this child had suffered a brain injury as a result of the low blood sugar, or the issue there. And the action was brought on that basis. So the patient's parents brought a claim on that basis to say you failed to give the feeds, there was this hypoglycemic brain injury, and now the child has cerebral palsy. As a result, you are liable as a hospital group for what your nurses failed to do. But on further investigation, genetic testing revealed that there was a genetic cause. So the brain injury wasn't a static type of injury that you'd see on MRI. It was a developing injury and the genetic testing pointed to a genetic rather than a blood sugar cause. And so that's a classic example of a horrific, terrible failure in terms of care, but has nothing to do with a legal claim, So yes, getting it completely wrong, dereliction of duty and so on, but not something that you can be held legally liable for. So I think that's something important to bear in mind. I think in your space as practitioners, you can make mistakes that aren't actionable. Not every mistake you make is going to result in a legal claim. You might have more exposure in terms of complaints. So the big thing is that HPCSA complaints don't require, or any of the regulatory body complaints, SANC also, and so on, they don't require harm. So all that's required is did you act, when regarders had your profession, did you act unprofessionally? Yes or no? Whereas the legal test is, did you act negligently? So did you act below the standard of a reasonable doctor, reasonable obstetrician, reasonable nurse, reasonable physiotherapist? And then importantly, did that negligence result in harm being suffered by the patient? So that's got to be there, and that's a classic example. Negligence, but that negligence didn't cause the harm at the end of it, where there was a genetic cause rather than a hypoglycemic brain injury.
So I've got a question here. It says, I'm a gynecologist in the private sector, and I have a standing order in hospital and the labor ward not to be called, or to be, being called out for patients that is not known to the doctor. It says, what if they call me and ask me to come out to see a patient, for example, in preterm labor? Can I refuse to come out and assess the patient?
So I think that's more of a hospital group challenge than I think a doctor challenge. And I know the position is generally that you have someone on call. So like that case I spoke about with the intensivist, I would be concerned as a private hospital group if I didn't have an on-call arrangement as part of admission and practicing privileges that doctors are expected to be part of the on-call thing. I'm probably treading on a lot of doctors' toes by saying that, but that's talking about it from a hospital group perspective. From a practitioner perspective, if you haven't committed yourself to be on call, then I think in most instances, you'd be able to get away with not getting involved. But yeah, if you've got a standing order not to call for private patients, then I think you can get away with that. Whether the hospital group is happy with that or unhappy with that's a different question. But if you were present in the hallway, for example, and you were called in, that might be a different situation. But if you're sitting off-site somewhere, then I think there's more room to argue. Yeah.
Yeah, I think it's the Bryce, especially where it comes to obstetrics, and the risks are quite significantly higher, as you know.
Mm.
Many times a patient goes on vacation and they are quite advanced in their pregnancy, and they arrive in Durban or they come up to Johannesburg, Cape Town, wherever it is, and suddenly the patient, exactly what the doctor points out, the doctor's never seen the patient. They've never assessed them. They've got no antenatal history about the patient, and suddenly they are called to tend to that pregnant, to tend to that, well, what they would refer to as an emergency. And many doctors are reluctant to just get involved because it's not always about saying I can quickly deliver the child and bill for it, but sometimes they are exposed in that regard. And I think that's why it's a relevant question for many of the doctors there.
I think we've dealt with 2 or 3 cases in the last few years where that was the situation, and the obstetrician ended up getting involved, becoming a party to the litigation where a child was born compromised. So it's hugely challenging. I do think, as I said, as a hospital group, it would probably be appropriate to take that step and to have someone on call dedicated, or a roster, so that the hospitals or the facilities risk is mitigated. From a practitioner perspective, yeah, it's a minefield. I think it is a very challenging situation.
So Javier, again, there are many wonderful, thanks for the informative presentation. Bryce, here you can see it's this wonderful and informative presentation. Then section 27.3, the focus is on may and be, right? So please advise of this non-instructive position. Lastly, can private hospitals not owned or operated by doctors turn a patient away for exhausted medical aid?
So just repeat that. If it's a patient that's admitted they've exhausted their medical
Yeah,
aid, can they be turned away?
that's correct.
Yes.
Especially they're not
No,
owned private, if it's not, the hospital is not owned by doctors.
uh, I don't think it makes a difference. I think if it's doctor owned, not doctor owned, there isn't a distinction. So I think the obligation exists, and that's what the National Health Act says in Section 5. It talks about practitioners, but also talks about healthcare facilities, and that's both private and public. So there's no distinction there about private healthcare facility or healthcare facility doctor owned or not doctor owned. The requirement would be the same. So if there's a medical emergency, the patient's not stable to transfer, and you were to turn them away, you're going to have a problem. Or if you try and transfer them when they're not stable because they don't have funds, then you're going to run into trouble. And that's not just from Section 27.3. I think that's from a legal claim perspective too.
Yeah, so there's a doctor in the private sector, yeah, Dr. Mate says, as a GP, I don't provide any obstetric care because I do not have the cover for it. And then can I refuse to provide emergency care, example, delivery with a client where their head is already on the perineum? So if complications occur, what protection do I have?
Yeah, then you hear of that frequently, and that is a huge issue because most GPs in the emergency unit setting won't have cover for maternity or obstetrics. Um, in that situation, you would need to deliver.
Yeah.
if you were the doctor in the emergency unit and someone came in delivering imminently, you would need to deal with them. You couldn't refuse to deal with them. But the reality is, where does that leave you if something goes wrong? As a legal person, the argument then would be the standard required is the standard of a reasonable GP in the circumstances. And look, that also goes to that other question earlier about, or that discussion we had, Burton, about uh, patients coming to Durban or Cape Town or wherever and ending up having to go into hospital to deliver with an obstetrician that they've never seen before. The requirement is, from a legal perspective, was your conduct reasonable as a reasonable general practitioner in those circumstances? So firstly, you're not required to perform to the standard of an obstetrician. The second thing is, the legal test is not, did you do what the best obstetrician would have done? The test is, did you do what a reasonable GP would have done or perform in the way that a reasonable GP would have in the circumstances? And then the circumstances that we're talking about is, you're not talking about an obstetrician who's seen a lady for 8 months, leading up, the whole way through the pregnancy, you've seen this lady, done the scans, got all the insight, whatever. You're confronted with a lady who's delivering now. You don't know if she's rhesus positive, negative, don't know if she's, hyper, PPH, whatever. You got no idea. So you are expected to perform reasonably in those circumstances. So I would, from a legal perspective, unless you did something horrifically wrong in that type of situation, you're not going to be held liable, because you don't have, you would have to mess up really badly to fall short of the GP's medical officer standard. And then secondly, the circumstances of an emergency case, where someone's presenting to you and you've got to make a plan. Yeah.
Thanks, bro. Yeah, this is a classic case, Bryce. You see it on TV where they always ask, is a doctor in the house? And the one question is, so you're a doctor, and I'm happy this doctor goes to the gym, and somebody gets injured in the gym. And so the question is, and I go over, I assist this person, am I allowed to charge for the consultation? I know you did raise it earlier, but yeah, please go ahead.
No, the Good Samaritan type situation, you wouldn't be able to charge, or it would be inappropriate. I think if you raised an invoice like in that case, then and someone complained to the HPCSA, you'd find yourself in trouble. But the emergency unit setting, so where someone's coming into an emergency unit, it seems like a silly or false distinction. But if someone's coming into an emergency unit, yes, you'd be entitled. But if you are called on the side of the street to an accident, and then you tried to charge for, sorry, if you were passing by, needed to assist with an accident because there was an emergency situation, or someone in the gym, and then you tried to invoice them, I think you'd run into trouble. But there is still the obligation, as I said, the obligation is there, but only if it's an emergency situation. Someone breaks their nail on a machine at the gym, and they ask for a doctor in the house, you fine. You can just carry on walking. But if someone, carry on lifting. Yeah.
Yeah, so evening,
If,
Bryce. Great presentation. Is verbal consent for transfer of a baby to a state facility enough in case of a private patient?
so we only got written consent in that case because we were worried. So in the norm, I think, as a pediatrician or a nurse in that setting, or a hospital, if you spoke to the mother, said, listen, we can't keep the baby here, we need to transfer, this is the hospital we've identified, so and so, the pediatrician there has accepted the patient, we've arranged for transfer, transfer is going to happen such and such time, is that an order? And they said yes, and you noted confirmed transfer with patient to such and such facility, EMS called, then that would be sufficient. I don't see that it's a strict requirement there to have written consent. If there's a debate and the mom, like in our one where the mom was making all sorts of threats, it might be a good idea to try and get written consent.
Yeah, especially with a gun. Yeah. And
Yeah.
then, yeah.
Yeah.
Yeah, so I got a question here. So I was pregnant 9 years ago and was high risk and had a 3 to 4 week ultrasound, and they never picked up that my son didn't have a right hand. Do I have a case of negligence?
Any obstetricians in the room? Or
Yeah.
would it be a radiologist, the ultrasound?
Yeah. Yeah. And by the way, if
I
anybody wants to ask a question directly, we can unmute and we will be able to, you can ask questions directly or participate. So please feel free at any point in time to ask us to unmute you, and you'll be able to ask directly, to speak directly to Bryce. Yeah.
Yeah, I mean that's a tragic situation. But the test again is, would a reasonable obstetrician have picked that up? And as a lay person, non-medical person, I wouldn't be able to comment on that, unfortunately. I haven't dealt with a case like that before to have some idea.
Okay. Then that's interesting. So one question is a toothache a medical emergency? There is a response here just on the side saying, yes, I believe so. We had a recent case where someone had mistaken a toothache for a minor issue and discovered that it's a stage 3 cancer, and sadly the person passed away.
So that's really interesting in terms of how do you know what's an emergency until you've assessed it?
Yes.
And how challenging that is in an emergency unit, for example, where someone presents with a complaint and it looks serious, and then you need to assess to determine whether it is or isn't. Look, I mean, that is perhaps a little bit like that case I was talking about in terms of the intensivist refusing to accept the patient, in that it's still, there's an element of an ongoing condition. It's not an immediate medical emergency. It's a cancer is a bit different. But again, pretty important to pick it up.
So we have your private patients may not have funds to do emergency scans in radiology department. In that case, how is one expected to treat a private patient that you can't even investigate properly in an acute setting? For example, CT emergency abdomen and acute abdomen. In addition, there's no available beds in a state hospital. So what is the recourse in that position?
Yeah, I think once you've admitted someone and then now you're trying to transfer into state, that is a big challenge. Yeah, from practically, I think that is a challenge, I think, in most instances. In terms of scans and paying for those sorts of things in hospital, it's a risk. I think as a practitioner, if you continue to treat, in that situation, you might be putting yourself at risk. And why I say that is there's nothing wrong with saying, well, if you can't afford it, yes, you can perhaps afford to be in hospital, but you can't afford to go for an MRI or, for whatever reason. So then you would, as a practitioner, it's a silly example, but like a knee injury, then you'd say, well, okay, you can't afford an MRI, but maybe we can do something else, an ultrasound or a whatever that's cheaper, and try and look at alternatives. But I do think that's where informed consent and note taking is important, because you need to record, advise so and so of importance of MRI scan in terms of determining issue. Informed, cannot afford it. I advised ultrasound as an alternative. Could afford, happy, not happy, whatever. So note taking, I think, in that context would be quite important. But if it got to a point, and I I'm struggling to see where, whether it would or wouldn't get to a point where you are so hamstrung in trying to deal with this patient that you just can't. Then I think you might have an excuse to say to them, listen, I can't treat you unless we deal with these things. And it would be in your best interest to be transferred to the state where they don't charge for that. So,
Yeah.
but again, and counseling a patient appropriately around that.
So patients' emergency treatment is relevant for documented or undocumented. I take it this is for immigrants in an emergency situation.
Yes.
Okay.
Yeah.
And
Yeah, no, absolutely. It applies across the board.
yeah.
And that's why, that section 27(2), the right to healthcare, is not only for citizens, it's also for persons present within the Republic,
Okay. So it doesn't.
documented or undocumented, yeah.
The question is no nationality, no race, disability, religion, nothing of that nature, right? Ability to pay or not.
Yeah.
And it says here, can you please clarify this for me? If a patient not on a medical aid presents to the emergency department of a private hospital, is the private hospital and doctor on call obliged to admit the patient to the ICU, or can the patient be transferred to the public hospital after being stabilized in the emergency department without being admitted to ICU?
I think it's probably about how long is a piece of
Yeah.
string. If the patient's stable enough to be kept in the emergency unit and then transferred straight away, then fine. If you probably wouldn't be subject to criticism, but if the patient's condition is so severe that there's a transport poses a risk, then you would need to admit into the ICU, I would think, in most instances. Look, just to be careful on that, I mean, I had a matter that actually, and we spoke about HBCSA inquiries, and we spoke about the disciplinary process there, and we spoke about legal action. But another consequence that one could face is an inquest in the case of a patient death, and then potential charges of culpable homicide. And I dealt with a case for a surgeon where the patient was admitted to a private hospital, had a procedure, was in high care, but was struggling a bit, not particularly stable, and they didn't have the funds to keep her there. And so the family wanted her transferred to this state hospital. That was all set up, had someone to accept, bed available, that side. And then the transfer happened, and the lady had a cardiac arrest and died as she arrived at the state hospital. And that was a 15-minute, it was 500 meters, but to get her from the high care into the ambulance was that sort of a length of time. And yeah, there the doctor had to answer questions at an inquest about why he allowed her to be transferred when there was a suggestion that she was unstable. Fortunately, we were successful in terms of defending his interests in that case. But yeah, that's the kind of risk that one can face.
Yeah, so there are comments here. I think it's inviting comments from the broader audiences. Can we get comments about Jehovah's Witness patients and blood products? So can a doctor refuse to deal or treat such patients if blood products may be required in an emergency situation, yet the patient is adamant about refusal to get such products? So it's yeah, we have recently dealt with such a matter through the ombudsman. So, but if you do have any information that Bryce or dealt with a case like that, feel free.
I think you could get into trouble. It's different. A minor is a different situation. So, the frequent route there is to deal with the courts around a transfusion if it's a minor and the parents are refusing. But if you are refusing to treat an adult patient or any, in fact, a minor patient too, because they're Jehovah's Witnesses, I think you might end up with trouble around discrimination, and fall foul of that. So that's my take. I haven't come across a situation like that before, but I would be concerned about that.
Good evening, Bryce. Does PIA and the POPI Act prevent the sharing of patients' medical records between healthcare practitioners? You ask a patient to get results for tests done at the public health center, and they are told to ask you to do your own tests. Their results will not be shared.
That's that's highly unethical, I would think. Look, the Act Poppy specifically says one of the exclusions is that you can share for as part of the treatment process. So
Yeah.
that's nonsense about not sharing because of Poppy or whatever. They should actually be providing those results on request.
Okay. And then where does the practitioner stand where the pregnant woman refuses obstetric care by a different obstetrician, standing in for the current the acting obstetrician, so like a locum, and the intrauterine death occurs while the woman wanted to be delivered by her own obstetrician.
I think again, note-taking records, recording the fact that you counseled her and said, listen, this is an emergency situation. I need to deal with you. That she refused, and yeah, the circumstances around that refusal. I mean, it's similar to the refusal of hospital treatment type form, the RTHC, the RTH forms. And obviously it's not, patients can still decide. They're entitled to make those sorts of decisions about their health, and around their treatment. So I think that that's perfectly reasonable, but again, you've got to record. It's perfectly reasonable in those circumstances to say, well, what can you do?
Yeah, I think we're coming towards the end of the the panel of the report as responding to each other about the patient, or at least our colleague whose son, the right hand was missed. So I'm seeing that on scan, I'm seeing some of the comments coming through, and I'm sure that those others we will get further information and respond to those. And then also on the Jehovah's Witness matter, there was a pediatrician out in Durban. I actually spoke to her not too long ago, and she had a patient, a young, a young child who required blood. The family, they are Jehovah's Witnesses, and so the pediatrician knew that the child needed blood products to save the child's life. And so the pediatrician went ahead, knowing the position of the family, their religion, and gave the blood products and saved the child's life. So the question was whether or not the mother acted, or at least the doctor acted appropriately. So I remember at varsity, they would tell us that when you are sitting in court one day and you have to explain the situation about this child, if the child did not receive help, the child is no more. And you can't reverse the situation. You can do nothing about it. But if indeed you gave the child life-saving support, including blood, for instance, and the child is alive, even though no parent is going to say, well, my child is alive, I do not want my child here anymore. But obviously, so the doctor was exonerated in that case. But just in general, those are difficult circumstances, as you mentioned, especially
Very,
where the child is concerned, to
very.
go through the court in the first place. Yeah. Um, Bryce, I don't see any further questions. I'm just going to remind. Um, okay, there's a comment here. I recently had a Jehovah's Witness patient coming in for surgery. She requested that we do not give her blood unless it is absolutely necessary. And if I do give her, I should not inform her. Legally, where does this put me? What happens if she finds out by means, not me? Can she sue me?
That sounds about the right approach, but yeah. Look, if that's a sort of a, it sounds like you could probably rest assured it's not going to become an issue. If that's her position and if she was to find out, it sounds like it's fine. But yeah, look, maybe to be cautious to the nth degree, something in a note somewhere saying that that's what's been said, would assist.
Okay, I think we've got one more question and then we can call it a night, Bryce. You have an unstable patient in ICU, unstable. Relatives want patient to be transferred to their own doctor. You talk to your colleagues. She or he accepts the patient. Is this ethical? What happens if patient dies en route and who is responsible?
Yeah, that's almost like the situation I dealt with, that inquest. And yes, it was done with the family's consent. They had power of attorney, or the necessary documentation in terms of taking those decisions. And the doctor still ended up in an inquest where the patient passed. So I would be very cautious about that, and say, listen, counsel them appropriately. It was different, the baby ICU story. I didn't mention it when I went through the case, but what happened there was the mom then said, when the state, she really didn't want the child to be transferred into a state hospital. And she said, well, discharge, I want the child to be discharged to me. I want to take the child home. And the pediatrician had to say, listen, if I give the child to you, she will die within half an hour at most. I cannot give discharge the child. And she was insistent. So that was part of the pediatrician then refused, said that I'm not discharging the child. So I think that if that's different, because you're acting in the interest of the child, you would probably then need to try and make some kind of an application to the court to make a decision about the child remaining admitted rather than being discharged to the mother, if you were going to take the proper legal course. So I think that the best you can do there is to make absolutely sure that the family has the necessary authority to make that decision. So have the documentation in place to evidence that, and then to note that you've counseled them about the risks involved. And it's useful. I mean, you often see it in terms of informed consent, where doctors will write explained risks. That's great as a start, but it's helpful if you can, and obviously it is more onerous than just saying advised of risks, but it's useful to say advise them of risks inter alia, or including bang, 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 and explaining, if in that context, risk of collapse, risk of cardiac arrest, risk of respiratory arrest, risk of death, so providing detail. It's fine in court. You can also just say, yes, I noted informed of risks. What that means in my practice is I would have told them, not necessarily even I did. I would have told them these, of the following risks. So yeah, in summary on that question, I would make sure that you've satisfied yourself, got the necessary documentation to establish that the family are entitled to make that call, or that whoever you taking that instruction from, that they can make that call. And then secondly, that you've counseled them on the risks of transfer. I would still be worried having done that, but you would likely be okay from a court perspective if you did that.
Yeah, Bruce, and really fine. I'm going to give you the real examples where patients coming from the UK. It happened on two occasions actually, and the they needed to go back, and so the dad had come along and he fell ill and ended up in ICU, and the family needed to return to the UK, and they gave the instruction for the doctors to turn off the machine so that the dad could pass. and they would be able to go back in a different situation was really similar in scenario.
Mm.
And so it was kind of interesting and a tricky situation in terms of, because it came to the hospital manager, how is it that we're going to deal with this matter? And so we took the guidelines from the HPCSA, which clearly made it a point that number one, if the patient had given some form of proxy when the patient was compos mentis beforehand, that the patient had given a clear instruction not to be resuscitated, that was first. And then the second authority, if that was not in place, it had to go through the high court. And it went all the way down to the children are right at the bottom.
Mm.
So even as a family, as children, because they were looking at who has to gain from the death of the patient in terms of the permission. And so
Yeah.
for everyone to look at that, that is also quite an important consideration when you find yourself in those situations, and there are guidelines. Bryce, you have given us so much of your time, and we truly appreciate it. And thank you for graciously answering all the questions, as many as can. If there are any others, we will certainly forward them to you and then return that to our colleagues. So you can see everyone's clapping hands and thanking you so much for the presentation. Really informative. And again, colleagues, please don't forget to nominate each other for the Health Excellence Award that will be coming up soon. And the closing date is on the 6th of October. And yeah, we hope to see many of you, if not all of you, there on that evening. So thank you very much to the Clinix Health Group, all our colleagues, Tolekele and the team in the background. Thank you for keeping everything working efficiently and effectively. And colleagues, we hope to see you soon again next week, Thursday, for another session. Thank you very much. Thanks, Bryce.